Good morning, everyone, and welcome to the latest in this Think Tank series. My name is Rhys Thomas. I'm joined today with our expert panel where we're going to be discussing all things CIS and IR35 and the interaction between the two. We've spoken to a number of construction industry businesses over the last year who have automatically assumed that CIS takes precedence over IR35. And as we now know, that's not the case. HMRC has confirmed that off-payroll will take precedence over CIS. So it's something that construction companies need to be thinking about when planning for the off-payroll reforms coming into place next week. So as I say, today I'm joined with the expert panel to explore when the off-payroll rules apply to the construction industry as a whole. So I'd first like to give a brief summary to our listeners of both the off-payroll rules and the CIS rules. Carla, perhaps I can come to you first of all to just explain briefly the off-payroll rules, when those apply, and a short summary of what people can expect from the reforms.
Yes, the off-payroll rules apply when a contractor is engaged to deliver services to an end client through his own intermediary, which is called a personal service company. And in those circumstances, under the off-payroll rules, if they're deemed a medium or large company, they need to do an assessment of the contractor's status to determine whether or not they're working inside IR35, which generally means under the supervision, direction, and control of the end client, or outside IR35, which means that they are genuinely self-employed and not under the supervision, direction, and control. Plus, there's quite a few other factors that need to be taken into consideration when making that determination.
Absolutely. We've got lots of videos on that. We've covered off-payroll quite extensively. So I'm hoping that people listening have a good understanding of it already. But in terms of the construction industry scheme then, Bernie, could I come to you for a very short summary on what that is, its implementation? Obviously, we know that it was implemented a while back for leakages in tax from the construction industry and contractors and subcontractors. Can you give a bit of colour to that?
Yeah, sure. So the construction industry scheme was originally implemented in 1999. And it's essentially a tax collection scheme that applies to construction activities only. But the definition of construction activities is very wide, so would encompass recruitment agencies who are engaging contractors to work in construction-related roles as well. And basically, the CIS scheme requires a withholding tax to be applied to payments made down the chain for any construction related work. So what happens is that what HMRC deem contractors, so sort of main building companies, when they make payments to what the scheme terms subcontractors, so people lower in the payment chain to them, there is a certain amount of withholding tax that needs to be applied. Businesses also need to register with HMRC for the CIS scheme, file monthly CIS returns, and then apply the deductions as well and report those to HMRC actually on payroll the same way that they report their employee payments.
And the contractor as well as some subcontractor needs to, well, the subcontractor doesn't necessarily need to apply or register under the scheme, but they will be charged a higher percentage in the event they don't.
That's right, yeah. So the standard withholding amount, if they are registered with HMRC as a subcontractor, is 20%. If they don't register with HMRC as a subcontractor, then the withholding amount is 30%. So, you know, a 10% difference, which when you're talking that's on the gross invoice value amount, that's not an insignificant amount. And therefore, most subcontractors do register with HMRC. Interestingly, if you're a recruitment business, then you act as a contractor and a subcontractor under the terminology used within the CIS scheme, because you're a subcontractor when you receive payments from your client, but you are a contractor when you make payments to your temporary workers, for want of a better term, because so then actually you need to register with HMRC as both.
Yeah. Okay. Tom, I can see you nodding your head. Is there anything you want to add to that kind of summary of?
Oh, I don't think so. I think that sums it up perfectly. There are circumstances where you can actually be paid gross under the scheme, essentially where your compliance as a business is without question. But as Bernie says, most are either subject to withholding of 20 or 30%, which, as Bernie has very clearly said, when that is on your gross invoice value, that is a significant cash flow issue.
Absolutely. Okay, so the purpose of today, now we've gone over the separate rules. This is not a deep dive into the construction industry scheme or necessarily off payroll, because it's anticipated that those operating in the construction industry will already be aware of CIS and how it operates. But today's purpose is to think about how companies in the supply chain and indeed contractors can start preparing for the off-payroll reforms and their interaction with the construction industry scheme. So I think part of that, we need to have a look at the kind of principles around supervision, direction and control, of course, and how that applies to the construction industry scheme. But first of all, we probably need to start at the beginning with the off-payroll and how that's going to apply. Would anyone like to kind of take that on and start discussing? Bernie, great.
So the off-payroll rules do take precedence over CIS. So what that means is if the client is a medium or large size business, then they need to consider the off-payroll rules first. If they deem that a contractor is inside IR35, then the agency sat in the middle, if there is one, or the client, if it is the business that pays the contractor directly, then no CIS deductions are made because, of course, if a contractor is deemed inside IR35, then full PAYE has to be deducted. So CIS then falls away. If, however, the client determines that the contractor is outside IR35, then whoever pays the contractor applies the 20 or 30% withholding at that point. Similarly, if a contractor is providing services to an exempt client, then either the client or the agency, depending on who pays that contractor, they would apply the CIS withholdings as well. But one point to note, though, is that when it comes to contractors who are affected by off payroll, of course, it only applies if they work through their own intermediary, as Carla so correctly pointed out. And the vast majority of contractors who work within the construction industry are not PSCs. They're not limited company contractors. They are sole traders. So it's actually only a tiny minority that would be affected by off payroll and CIS. The vast majority of contractors, where they are sole traders, they will, you know, if there's an agency in the chain, then obviously instead the onshore intermediaries legislation applies instead.
So do we think that the kind of people affected may be people like property developers and those kind of companies that are providing, or people providing services through their limited company, rather than, as you say, the sole traders working on site somewhere? Is that the general, do you think that's where this is going to apply to those people?
Yeah, I think businesses that provide services to consultancies who operate within the construction industry, so sort of design and those kinds of areas, technical, IT, it's all part potentially of the wider construction industry, but it isn't trades and labour, if you want to term it that. They might be PSCs, but as I said, the vast majority of the people who actually do construction work in its purest form, yeah, they wouldn't be personal service company contractors.
Okay, perfect. So on that basis then, if this is going to affect a smaller population of people, perhaps it's worthwhile trying to go into a little bit more depth on the off-payroll rules to be a bit more explanatory for that. There's a clear hierarchy to this process of how you work through the process of deciding which set of rules apply. And as we've all said, that starts with an IR35 assessment. Carla, I wonder if, or Carla or Layla, if you want to talk through initially the kind of principal steps of an IR35 assessment, what companies need to be looking for when they're doing the IR35 assessment, who needs to be doing the IR35 assessment, and how they can do it. Obviously, we've got tools like the HMRC CES tool. There are third-party tools, but what are the things that people need to be looking out for in terms of doing those determinations?
Layla, do you want to deal with it?
Sure. So when looking at your IR35 position, I think it's important that everyone knows you need to look at the contract and the working practices to make the determination. And depending on whether or not the off-payroll rules apply, that determination it's done by the end client if they're medium or large size company. And that determination is based on 4 main pillars that we look at, which is supervision, direction and control, mutuality of obligation, financial risk, and I always forget one. Substitution, which is probably one of the most important. So when looking at these 4 main pillars, you need to kind of assess and ensure that each of these apply, and that you're working on the basis that you're an actual business rather than an employee of the company. So part and parcel of the company is also a major factor in that as well. So when you look at substitution, you need to look at whether or not you have the unfettered right to substitute and you've actually used the substitute, because in a lot of instances, a lot of contractors haven't actually used that substitute. So when you have that opportunity or you can use the substitute, I think that's a main factor in that area. Supervision, direction and control, I think it's clear that you should have autonomy on how you perform the tasks, when you perform the tasks, where you perform the tasks. Obviously the client can give some guidance around that and you can discuss it with the client, but effectively you need to be making those decisions. Financial risk also, I mean, I think that is quite self-explanatory. You need to have the required insurances and actually have that real financial risk of having your own business. And then when you look at how you interact with the client and whether or not you use their facilities, whether you have management responsibilities within the company, you just need to step away from being an employee and being seen as an employee rather than and rather just acting as a business of your own right. So you won't go to Christmas parties, you won't use their gym or canteen. And you won't manage staff in the client's company. So I think it's a well-rounded view, which there's a lot of factors to take place to have that determination.
Okay, fantastic, thank you. And so obviously companies operating within CIS or the construction industry are going to be pretty adept with the idea of supervision, direction and control already. That's a consideration in terms of assessing that. So looking at other things around those key points that you've raised there are going to be essential to doing that assessment. However, clearly there's going to be a lot of new territory in terms of an assessment. The point is that those operating within the construction industry need to first of all look at the whole workforce, don't they? That's where they need to start. Then they need to assess which ones are working through PSCs, which ones are working as sole traders, which ones are genuinely self-employed. Then for those that are operating through PSCs, they need to then apply the off-payroll rules first of all, work through that and determine whether they're inside or outside IR35. If they're inside, they're paying obviously net and retaining that as the off-payroll rules apply. And then outside, they're then moving on to the CIS rules. So it's quite a straightforward process in terms of those that have to do it. But I think the consequences are quite severe. And I think, Tom, you're probably best to talk around this in your role as Director of Tax Investigations, to look at how HMRC might start to apply this. As Bernie said, this was implemented a long time ago to prevent leakages in the tax system. The other rules around the VAT recharging in the industry as well has also been motivated by that. So surely HMRC are going to be pretty hot on this and be looking, even if it applies to a small percentage.
I mean, let's start at the beginning here. I mean, Bernie said, you know, Cis, as kind of as we know it, was 1999. You can actually trace it back to 1972 when they first brought the initial construction industry deduction scheme in. And it was brought in because it was seen largely as a non-compliant industry. The biggest risk being that people would be paid gross, not be registered with the Inland Revenue as it was then, and essentially disappear off the face of the earth without paying any tax. And it was considered to be pretty rife in the industry. Then they brought the system in the 70s where you were paid under deduction. So you had what was called an SC60 at the time. It basically said, this is the tax that's been deducted. You put that with your tax return and you get credit for the tax at the end of the tax year, roughly. And I think it's by and large recognised that wasn't not open to abuse. You know, I remember as a kid, my dad was in the industry. SC60s would openly be traded in the pub. You know, it was still a non-compliant industry. Cis, as we kind of know it today, was brought in, as Bernie said, 1999. And I remember it well because I was a young revenue officer at the time, having to register all these subbies. Friday afternoons in the inquiry centre was interesting, to say the least, at times. But it was basically designed to force everyone to be on HMRC's books, whether that be paid gross or whether it be paid under deduction. And that's essentially where we are today. Problem being is that having registered with HMRC as a subcontractor and saying I am a self-employed person, it's generally just accepted that these people are self-employed people. And I think the Revenue's view is that in a vast amount of cases, actually many subcontractors are not self-employed people. They are under supervision, direction and control of contractors. They essentially are told you will be on this building site on this day, you will lay this many bricks. And although I may pay you a day rate, that's why we're saying you're self-employed. Reality is that there is an element of SDC there, probably enough to make them employees. So for a long time, the Revenue's focus was on, okay, how many of these subcontractors are actually, their status is wrong and they actually should be employees? Of course, quite key for the Revenue because then they can go after employers, national insurance on top of what the tax would have been paid by the subby anyway. So there is additional tax there for HMRC to gather. We now move into a world where, I mean, IR35 has always applied. Nothing's changed. It's just, of course, we're now moving into a world where the determination is on another party. And therefore, this is another opportunity for the Revenue to come back and say, OK, are the rules being operated correctly? This is a new in for us. We can go after the end clients and the bigger consultancies to look whether they're operating the rules. So this is a wider piece of work here, not just around IR35, but also actually, are these people genuinely self-employed or are they employees in the first place? It's almost the first test before we even get to that.
That's really interesting. And I wonder whether HMRC are going to use that, as you say, as an opportunity to open up and examine Cis a little bit further then, because they can get in at the kind of top end quite comfortably. With the interest in off payroll. You see that happening?
I think so, because I think there's essentially a two-pronged attack that can happen. You can initially look at the status, and then once you determine the status, I mean, of course we've got different scenarios here. But Bernie's talked about agencies, and that poses a different set of risks. So I'm talking here more about the kind of subcontractor and subcontractor PSC type arrangement. But yeah, and initially they can get in and look at that supervision, direction and control, and then move on to the kind of IR35 issues that are also around that. So there's more than one way to skin a cat, I think is the way HMRC will see it.
Yeah, that's interesting. Bernie, do you have anything to add to that view? Obviously dealt with that kind of world for a while.
I mean, well, you know, we know that, I mean, there are additional changes to the CIS scheme that take effect from 6th of April this year that don't change the CIS scheme fundamentally, but you can tell that HMRC are gearing themselves up to be able to enforce the rules better. So things like not registering with HMRC for CIS, the penalties will now be increasing. HMRC's ability to deem somebody as a contractor, as in the, you know, a main sort of building company, if they've not registered with HMRC, and HMRC's right to set off as well. So there are quite a few things that they've tweaked over time, but these additional changes that are coming into force next week around CIS just go to show that HMRC are still pursuing tax loss in and around the construction industry scheme. And yes, if the contractor is a PSC, obviously, you know, they can use off payroll, but they know and they understand, they appreciate that the vast majority aren't PSCs, and therefore they've got other ways, you know, to pull and investigate any tax loss that they think is happening, using the CIS rules as well. And I think they will go after both. I think they will look to construction companies for both off payroll and the use of sole traders under the CIS scheme, because, you know, it's still not an ideal scenario.
It's an onerous process, isn't it? It's quite onerous for the construction industry, those operating and the agencies. They can have to think about this quite carefully. Interesting. So in terms of a movement forward, as we said, there's a checklist, I guess, in terms of what those companies need to do to work their way through it. Obviously, if anyone listening wants to have a chat around that checklist and just make sure that's watertight on a free consultation basis, please feel free to call any of the panel today, who will be happy to help. But I think from a more comprehensive offering, there is the IR35 Navigator that sits in there, and that would conduct all of the reviews through a platform. It would house all of the contractors or the applicable contractors on off payroll into one place via one platform. So that could be an option clearly for a lot of people listening who want to streamline that process into something a little bit more coherent and not have to undergo the huge sifting task that's going to have to happen, which is going to be interesting to watch and difficult to manage. Great. Okay. So I think that's explained both CIS and off payroll. The overriding message is that off payroll overrides CIS. So companies need to be looking there first and then moving on to CIS post that. Is there anything anyone else would like to add before we leave it there for today?
Reese, could I just ask Bernie to clarify the importance of the Onshore Intermediaries Act with respect to CIS? And I know that was brought in, I think, in 2014, and the effect that had on both agencies and on, say, consultancies or contracting companies who provide services to their end clients. Just a question to Bernie myself, whether or not that captures, when they speak of the intermediary there, are they referring to both the agencies and those contractors? Because I think it's quite a broad definition.
It is a broad definition, but when they're the intermediaries for the purposes of the onshore and offshore intermediaries, because the legislation, both types were brought in on the same day in 2014, as you so rightly said, they are talking, the intermediary is somebody who is involved in the supply of people. So it is targeted specifically at recruitment agencies. Technically, consultancies would also be included. I think the vast majority of them don't apply the onshore intermediaries legislation necessarily, but obviously certainly agencies do. So then they are under a different additional obligation that isn't there for end clients who engage with sole traders directly. Now, obviously, end clients who engage with sole traders directly are under an obligation for anybody that they pay under the pay-as-you-earn regulations to do a certain amount of due diligence as to whether individuals that they are paying are genuinely self-employed for tax purposes or not. But that's a little bit more woolly, if you like, than the onshore intermediaries, right, which applies when there's an agency in the chain, which is a very specific defined requirement, a very specific thing that agencies have to do before they're allowed to pay a sole trader gross or under deduction under CIS, but whether they can pay them at all without deductions for tax and NICs. And that is to do what's called a supervision, direction and control test, which is not the same as supervision, direction and control under IR35. No. It's very similar, but it's not exactly the same. And it is a narrower, more specific test. But it is harder because the burden of proof is against you as the agency. So by law, you must deduct tax and NICs from sole traders unless and until you can prove that no supervision, direction, control is present and no right of supervision, direction and control is present. And then, and only then, could you pay gross. And then if they are within the CIS scheme, then you would make the deductions. So for agencies, there's even more steps in the process and the burdens are much more onerous.
Right. So that legislation was targeted really at agencies who presumably will subcontract to umbrella companies in many circumstances.
Yes, they will, but they can't outsource their legal responsibility because the onshore-offshore intermediaries act to put the highest agency in the chain as primarily liable. So the agency closest to the client is who HMRC goes to first. Right. So if an agency decides to subcontract this SDC test to a payroll intermediary, that payroll intermediary holds no legal liability whatsoever. It is the agency closest to the client who is primarily liable and responsible for any unpaid taxes, which is one of the reasons why MSPs and RPOs do not allow second-tier agencies to use sole traders or limited liability partnerships or any other type of self-employed that is not a PSC. For that reason, because of the onshore intermediary.
Right. Yeah, thank you for clarifying that.
What
So
an answer.
It's been a little bit confusing.
Hell of an answer off the cuff there. For those who don't know Bernie is a specialist working for a company called Labvolution. So if anyone has any further questions around that point, feel free to contact Bernie directly. Great. Okay. I think any other questions, any other points that anyone wants to raise?
I would just like to kind of say how there is a huge administrative task now on these individuals, and could be quite daunting kind of going into it and knowing where to start. So maybe to list out a few things to recommend, I think you first should start by reviewing your current workforce, as we mentioned before, conduct a sort of audit in the supply chain, establish where you sit in those chains, and this will help determine what your obligations are, and then kind of identify those workers, PSCs or self-employed, who could fall under any of the rules. Start a discussion with the workers about off payroll and whether that applies, and make sure that you have clear communications with your workers, and then go from there. Start making the status determinations. And I mean, engaging a professional service usually helps with complying with reasonable care in HMRC. I think that's a big point that everyone has established, is to make sure that you do have reasonable care when you do make your determinations, because it is a daunting task and it can be quite confusing.
Absolutely. Yeah, completely agree with that. Thank you. Anyone else?
I was just going to add, Reese, that it's highly likely, with all the sort of changes going on here with off-payroll working, CIS rules, also reverse charge VAT, that it's highly likely that there are going to be more engagements that are going to be placed or offered via an umbrella. And I think here it's just worth reminding everyone that umbrellas, in the general term, are organisations that are there to, provide a payroll service, but there are many companies out there that hold themselves out to be an umbrella when indeed they're not. And so this area of the industry, which is not regulated, is quite rife in terms of tax avoidance schemes, and it's even more important now, particularly with the new rules, that everyone looks at their supply chain to make sure that everybody involved in that supply chain is legitimate and carrying out their responsibilities under the rules, and that applies to everyone.
I think that's a really good point, Chris, because I think traditionally the type of arrangements you're talking about that hold themselves out as umbrellas have probably been targeted at areas where IR35 has been a known risk. So consulting sectors, IT, that sort of areas. Clearly, with the changes, more people are being brought into the scope of IR35 or being asked to work in a different way because of IR35. So there are going to be industries that are just not familiar with these avoidance arrangements and being very attracted to the kind of 85% take homes that are being promised. So I think that's a really good point to just emphasize and say, I hate to say it because it's an HMRC motto, but there is an element of truth to it. If it's too good to be true, it probably is something you should be double checking and taking advice on.
And I think HMRC are very cognizant of that. I mean, obviously some of the feedback that was given to HMRC as a result of the 2017 public sector off-payroll rules were that, we saw lots and lots of individuals going into non-compliant payroll arrangements. I won't call them umbrella because umbrella generally means a compliant PAYE umbrella, but, the clients thought, or agencies thought, and even possibly the workers thought that that's what was happening, but it wasn't. And interestingly, HMRC have shored that up even further as a result of the 2021 finance bill, in order to ensure that they now put in place that targeted anti-avoidance rule that makes it very clear that, particularly in an arrangement whereby a client has deemed a contractor to be inside IR35, if you then utilise a payroll arrangement such as an umbrella, if there is tax avoidance going on in that chain, then HMRC is able to pursue and will pursue the highest person in the chain involved in that arrangement. So you've got to do even more checks to make sure that you as a client or an agency or even the individual worker, that you're not getting yourself involved in any kind of avoidance or evasion arrangements.
Absolutely. I think there's going to be more requirement on those higher up the supply chain to do proper supply chain audits, understand what's going on at all times, which is just another level of onerous task, but it's so important considering the liability shift. So yeah, absolutely great point to raise.
We keep saying onerous tasks, but this is...
Yeah, it's just got to be done, hasn't it?
Yeah. Reality of owning a business. These are your responsibilities. And if you want to be in this industry, I'm afraid these are the tasks that you're going to have to undertake. And if you're not willing to do that, then leave it to people that are. I'm going to be as blunt as that. Yeah,
I saw a post on LinkedIn which said that every company needs to, when you're running a business, you need to take an understanding of the legal requirements that affect your business. So this isn't just something necessarily being thrust upon you. It's a new or an existing piece of legislation which is being extended, but you got to get used to it. You got to crack on and put it into your processes. I agree with you. I think that's probably the wrong phrase to use, onerous task, but it is onerous and people will find it daunting and unsettling and nervous. But as Layla said, there's a clear path to squaring away your compliance, and there's a clear threat to not doing it properly. And at the same time, if we're talking about SWAT, there's a clear opportunity here to shore yourself up for the future and evidence your compliance steps to potential clients and win new business. So I think there's a lot going on, and it will be an overwhelming perspective, but hopefully we've evidenced on the call today that actually there's some simple steps that can be taken which interact with your current processes, just a little bit of an add-on. And as Tom said, there's opportunities there for you to work with professionals on a consultation basis, first of all, to make sure the framework's correct and implemented, and then perhaps on a more integrated way moving forward to conduct the assessments and the status determination statements. So yeah, I couldn't agree more. Business as usual. Good. All right. Anything else anyone wants to add? Any other nuggets of information? No? Well, that's fantastic as always. Thank you all for bringing your informative opinion to the situation. Really appreciate it. And I know our listeners do. So thank you for your time. Enjoy your long weekend and we'll see you same time next week.